There is a sentence that gets said in land offices across Thailand almost every working day, usually in English, usually by somebody who is being helpful rather than dishonest. And it goes something like this: "Don't worry, it's the same thing." It is said when a foreign man asks why his name isn't going on the document. It is said when a couple are told that the land has to be registered to one of them, and only one of them is legally capable of holding it. And it is said, most often, in a room where everyone present genuinely believes that the paperwork is a formality and the relationship is the substance. What I want to do here is take that sentence apart, because it is the single most expensive misunderstanding in Thailand, and because the law underneath it is not actually complicated. It is unfamiliar, which is a different problem. Unfamiliar things can be learned in an afternoon. What follows is that afternoon. Start with the foundation, because everything else is built on it. The Land Code of 1954 governs who may own land in Thailand, and the answer it gives is Thai nationals and Thai majority juristic entities. Section 86 provides that foreigners may acquire land under the provisions of a treaty. That sounds like a door, and for a long time it was one, but the last treaty permitting foreign land ownership in Thailand was terminated in 1970. And no such treaty exists with any country today. So the exception is real in the text and empty in practice. A foreign national cannot own land in Thailand, not after 10 years of residence, not after 20, not with a work permit, not with permanent residence, not with a Thai wife, not with Thai children, not by paying tax here for a career. The rule does not soften with time or contribution, and the number of foreigners who assume otherwise because their circumstances feel special is very large. There are narrow statutory exceptions that exist and are worth naming, if only so you know what shape a genuine exception takes. Foreign companies making substantial investments that benefit the Thai economy may be granted landholding privileges through the Board of Investment or under the Industrial Estate Authority framework for the duration and the purpose of the promoted activity, with Ministry of Interior approval, and typically capped at a few rai tied to the promoted business. Section 96 bis provides a residential exception for foreigners bringing in a very substantial qualifying investment. In practice, these routes are used rarely and are not what the retiree buying a house in a provincial town is dealing with. If somebody tells you they have found a way to put land in your name, and it does not involve the Board of Investment or a treaty that does not exist, they have not found a way. They have found a structure, and structures are the subject of a later part of this. The one clean exception, the one that works, is the condominium. Under the Condominium Act, a foreigner may own a condominium unit outright, in his own name, in freehold, with a unit title deed, provided that foreign ownership across the building does not exceed 49% of the total saleable floor area. That is real ownership. It can be sold, mortgaged, inherited, and it does not depend on anyone's goodwill. It requires that the purchase funds be remitted into Thailand from abroad in foreign currency and documented on a foreign exchange transaction form, which is the bank certificate that the money came from outside the country, and which you will need again when you sell. If a foreigner wants an asset in Thailand that is unambiguously his, the condominium is the answer, and the reason it is so often rejected is that it is an apartment, and the dream was a house with a garden. That is a legitimate preference. It is also, legally, the point at which every complication in this video begins. Now the marriage question, because this is where most people's situation actually sits. Before 1999, a Thai national married to a foreigner was in an extraordinary bind. Thai matrimonial property law treats assets acquired during a marriage as sin somros, marital property, jointly held. If a Thai woman married to a foreigner bought land during the marriage, that land would become marital property, and her foreign husband would acquire a half interest in it by operation of law, an interest the land code forbids him from holding. The practical result was that Thai citizens who married foreigners effectively lost the ability to buy land. They were Thai. They had the constitutional right, and the mechanics of matrimonial law shut the door anyway. That was resolved by a Ministry of Interior regulation issued on the 23rd of March 1999, circulated as Urgent Letter More Thor 0710 or 792, and the mechanism it created is one that a great many foreigners have signed without reading. The regulation permits the land office to register land in the name of a Thai national married to a foreigner, provided both spouses appear before the competent official and jointly execute a written confirmation that the money used to purchase the land is the personal property of the Thai spouse, Sin Suan Tua, under sections 1471 and 1472 of the Civil and Commercial Code, and is not the personal property of the foreign spouse, and not jointly held marital property. Section 1472 supplies the logic. Where personal property is exchanged for other property during a marriage, the new property remains personal rather than becoming marital. Without that joint confirmation, the registration cannot proceed at the local office and must be referred up to the land department for ministerial approval, which in practice means it does not happen. Read that again slowly, because the shape of it matters more than the citation. The document you sign is not an acknowledgement that the land is in her name for administrative convenience. It is a declaration, made to a state official, that the money was never yours. It functions as a waiver. You are affirming on the record that you have no proprietary claim to the funds that bought the land, and therefore none to the land. People sign it in 10 minutes on a hot afternoon at the end of a long process, with an agent translating loosely, understanding it to mean roughly, "We agree she holds it." It means considerably more than that, and it means it against you, in writing, with your signature on it, held in a government file. If the marriage later fails and the question of that land reaches a Thai court, the declaration is the first document produced, and it was produced by you. I want to be careful here, because it would be easy to make this sound like a trap laid for foreigners, and it is not. The regulation exists to restore a right to Thai citizens that the interaction of two laws had accidentally removed. It is a fix for their problem, not a snare for yours. But it does have a consequence for you, and the consequence is that the standard, entirely legal, entirely above-board route by which foreigners fund the purchase of Thai land requires them to put in writing that the money wasn't theirs. Everything that people later find shocking about their position flows from that document, and the document was not hidden. Divorce is where that document does its work, and it is worth being specific about the mechanics, rather than leaving it as a vague warning. Thai matrimonial law divides property into Sin Suan Tua, personal property, and Sin Somros, marital property. On divorce, Sin Somros is divided between the spouses. Sin Suan Tua is not divided at all. It belongs to the spouse who holds it and leaves the marriage with them. Land registered under the 1999 procedure has been declared, by both spouses, in front of a state official, to be Sin Suan Tua. It is therefore, on the face of the record, outside the pool of divisible assets entirely. There are arguments available in some circumstances: a claim in unjust enrichment, a claim founded on a documented loan rather than a gift, an argument that the declaration does not conclusively determine the true legal character of the asset as between the spouses, and Thai courts do sometimes look behind form to substance, as the gift cases show. But those are contested claims requiring evidence, brought against a document you signed saying the opposite, in a language you may not read, and litigated in a Thai court over a period of years. That is a materially worse position than not having signed it, and the alternative was never available. Without the declaration, the land could not have been registered at all. This is the fork in the road, and it comes at the very beginning, which is why the useful protections described later in this video are the ones you register on the same day, rather than the ones you consider afterwards. Death raises the same wall from the other side. Section 93 of the Land Code contemplates the Ministry of Interior permitting a foreign statutory heir to inherit land, but it must be read together with Section 86, which ties acquisition to a treaty, and since there is no treaty, the provision does not operate for a foreign spouse inheriting from a deceased Thai spouse. The foreigner may inherit as a matter of succession law. He cannot register ownership. Under Section 94, he is required to dispose of the land within 1 year of acquisition, and if he does not, the state can force the sale. So the man who has spent 20 years in a house he paid for, whose wife has died, is not permitted to keep the land, He is permitted to sell it and keep the money, which is not nothing, and is also not the outcome he expected on the day he signed the confirmation letter. Condominium units are treated differently. A foreign heir may register a unit, subject to the building's 49% quota, and where inheriting would breach the quota, there is a notification requirement and a 1-year disposal period. One practical point on succession before moving on, because it is cheap to fix and routinely neglected. If you hold Thai assets, a condominium, a registered lease, a superficies, a bank account, a vehicle, you should have a Thai will covering those Thai assets, drafted in Thai, executed to Thai formalities, and held somewhere retrievable. A foreign will can be recognized, but it will require translation, legalization, and a probate process conducted through a Thai court on a document drafted for a different legal system, which can add a year or more and a great deal of cost, while the assets sit frozen and the surviving partner has no access to anything. A short Thai will dealing only with Thai assets, running alongside a home country will dealing with everything else, costs very little and removes an entire category of avoidable misery. It also lets you name an executor who is actually in the country, which matters more than it sounds. That covers purchase and inheritance. Now the gift, which is a distinct legal act with its own rules and its own irreversibility, and which comes up constantly because gifting a house or land to a partner's family is one of the commonest things foreigners do in Thailand. A gift under Thai law is a contract, governed by sections 521 onwards of the Civil and Commercial Code. Where a movable property is concerned, the gift is completed by registration at the land office, and on completion, ownership has passed. Fully, the Dunny is the owner. She may sell, lease, mortgage, gift onward, or leave the property to whomever she chooses, and she requires nobody's permission to do any of it. There is no lingering interest retained by the donor, no implied condition that the property will be used as discussed, no unwritten expectation that carries any legal weight whatsoever. If the transfer is registered as a gift, and you were the donor, you have given the thing away, in the fullest sense the law recognizes. The law does provide for revocation, and it is narrower than people hope. Section 531 permits a donor to claim revocation for ingratitude in 3 circumstances only: where the donee has committed a serious criminal offense against the donor, punishable under the Penal Code, where the donee has seriously defamed or insulted the donor, or where the donee has refused the donor the necessaries of life while able to supply them. That is the exhaustive list. Ordinary betrayal is not on it. Deceit about intentions is not on it. Using the property in a way the donor finds appalling is not on it. Taking a loan against it is not on it. Section 533 imposes a hard timetable. Revocation cannot be claimed if the donor has forgiven the donee, or if 6 months have passed since the act of ingratitude came to the donor's knowledge, and no action at all may be brought more than 10 years after the act. 6 months from knowledge. That is a very short window for someone still deciding whether their life has just collapsed. Section 535 removes revocation entirely for certain categories of gift. Gifts that are purely remuneratory, gifts encumbered with a charge, gifts made in performance of a moral duty, and gifts made in consideration of marriage. That last category is worth sitting with, because a house transferred to a fiancé's family in connection with a marriage is a strong candidate for it, and gifts in that category are not revocable for ingratitude at all. There is a separate route in Section 528, where a gift is encumbered with a charge, that is, where the donee accepted an obligation as a condition, and the donee fails to perform it, the donor may demand the return of the gift. But that requires the charge to have been agreed, which in practice means written down, which means a gift agreement, which almost nobody executes because drafting a contract for a present feels like an insult to the occasion. There is a recent judgment that shows how strictly the courts read all of this. In Supreme Court Judgment Number 3745/2568, a Japanese national had transferred a condominium unit to a woman with whom he was in a relationship. The transfer had been registered at the land office as a sale rather than a gift, because he did not want his lawful wife to become suspicious. When the relationship broke down, he sought to recover the unit, and the court had to address 2 questions. On the first, It looked past the form to the party's true intention, and held that although the transfer was registered as a sale, it was in substance a gift made out of affection, which is a genuinely useful principle, and it cuts both ways. On the second, revocation for ingratitude, he alleged that she had forged documents and had maliciously filed criminal complaints against him. The court found that the alleged forgery predated completion of the gift, and so could not ground revocation, and that in filing complaints, she had merely exercised her lawful rights to protect her property, without malicious intent to defame or seriously insult him. He had not established ingratitude. He did not get the unit back. The case is a clean illustration of the rule. Courts will look for what the parties really meant, and they will still read Section 531 narrowly, and being badly treated is not the same as being treated in one of the three ways the section lists. So a registered gift is, for practical purposes, final. Which brings us to the document that records all of it, and to the part that surprises people most. The Chanote, nor sor for jor, the title deed with the red Garuda at the top, is the strongest form of land title in Thailand. It follows a full cadastral survey with fixed boundary points. It confers ownership rather than mere possessory rights, and it is issued in duplicate, one copy held by the owner and one retained by the land office. The front bears the deed number, the plot's location and area in Rai, Nan, and Wa, the survey map, and the name of the registered owner. That is the side everyone photographs. The back is where the property's real story is kept. The reverse of the Chanote carries the encumbrance register, and every registrable right and event affecting the land is entered on it in sequence. Transfers of ownership, registered leases, mortgages, usufructs, superficies, servitudes, court seizures, official notations. It is a running ledger of who holds what interest in this specific plot, dated in order. Rights that are not registered on it are not enforceable against third parties. Rights that are registered on it bind everyone, including future owners. And that principle, registration, is what converts an agreement between two people into a right attached to the land itself, is the single most important idea in this whole subject. Everything that protects a foreigner in Thailand is written on the back of a Chanote. Everything that fails to protect him was a conversation. The Department of Lands provides an online mapping service, Lands Maps, and it warns explicitly that what it shows is basic information only and does not constitute legal evidence. A photocopy handed over by a seller or an agent is worth nothing at all. Forged Chanote copies with altered ownership details are a known and recurring fraud. The only verification that means anything is a title search conducted at the provincial land office where the land sits, with physical inspection of the office's original copy of the deed. A plot can look entirely clean on the front page while carrying several registered liens on the back. That inspection typically costs a few thousand baht through a lawyer and takes a morning, and the number of very large Thai property losses that would have been prevented by it is difficult to overstate. Now, mortgages. A mortgage under Thai law is a contract by which the mortgagor assigns a real right over immovable property to a creditor as security for an obligation, without delivering possession of the property. The owner keeps living there. The lender gets an interest recorded on the title. Registration happens at the land office, where the land is located, requires the original Chanote, the party's identification, the loan agreement, and any necessary corporate documents, and attracts a registration fee of 1% of the mortgage amount, plus stamp duty of 0.05%. On registration, the mortgage is annotated on the reverse of the deed and entered in the office's records, and that annotation is public notice to the world that the property is encumbered. Interest is subject to usury rules, generally capped at 15% per annum, unless a licensed institution operating under a specific exemption is involved, and compound interest is generally prohibited without express written agreement. Here is the part that lands hardest. The person who can mortgage the land is the registered owner, not the person who paid for it, not the person living in it, not the person whose retirement savings are physically embodied in the concrete. The registered owner, alone, walks into the land office with the deed and a lender, and creates the encumbrance, and no consent is required from anyone else, unless somebody else already holds a registered right over that land, which is precisely the situation almost no foreign occupant has arranged for himself. If you funded a house, transferred the title to a family member as a gift, and registered nothing in your own favor, then you are not a party to the title, you are not a party to any subsequent loan, you have no consent right, no notice right, no standing to object, and no legal mechanism to discover that a mortgage has been registered other than going to the land office yourself and asking to see the deed, which you are entitled to do, and which almost nobody does, because doing it feels like an accusation. There is a specific reason this scenario recurs in rural Thailand rather than being a random misfortune, and it is worth understanding without sentiment in either direction. In much of the Northeast, a household's Chanote is the only asset it owns that a formal lender will accept as security. Agricultural income is seasonal and undocumented. Bank lending to households without collateral is limited and slow. Informal lending, private lenders operating outside the regulated system, often at rates that would be plainly unlawful if anyone tested them, sometimes secured against gold, sometimes against nothing but pressure, fills the gap and rolls and compounds. When a family that has been servicing informal debt for years suddenly acquires a registered chanote on a new house, that document does not sit in a drawer as a keepsake. It is, in that household's economy, the first bankable asset anyone in the family has ever held, and it is immediately capable of clearing debts that have been grinding for a decade. What follows from that is not necessarily a plot. Very often, it is the ordinary logic of the situation asserting itself. The outcome for the person who paid for the house is identical either way, which is why the legal structure matters regardless of what you believe about anyone's intentions. If the loan is not serviced, Thai law does not permit the lender to simply take the property. There is no out-of-court foreclosure in Thailand. Enforcement is judicial. The mortgagee files a civil claim. The court examines the validity of the mortgage and the default and issues judgment, and the court then directs the legal execution department to sell the property at public auction. Proceeds go first to court and execution costs, then to the mortgagee in order of registered priority, and any surplus returns to the owner. Section 733 governs the enforcement right. There is a separate remedy in Section 729 allowing the mortgagee to take the property itself, but it is hedged so tightly, no interest paid for 5 years, the mortgagor unable to show the property is worth more than the debt, no senior encumbrances, that it is rare to the point of curiosity. The judicial process is slower than a Western foreclosure, and that is sometimes described as borrower-friendly, which is true in the narrow sense that it takes longer and requires a judgment. It is not friendly in outcome. Legal execution department auctions routinely clear well below open market value, particularly for rural residential property where the buyer pool is thin. A house that would fetch 3 million baht in an ordinary sale can be knocked down for a fraction of that, the proceeds absorbed by costs and the secured debt, and the borrower left owing the shortfall with the asset gone. And the foreign occupant, throughout all of this, is not a party. He is not served. He does not receive the notice of sale. He has no right to appear. He learns about it when the process reaches his front door, or slightly earlier if somebody happens to mention it. So that is the exposure, described accurately and without drama. Now the protections, which exist, are cheap, are registrable, and are used by a small minority of the people who need them. The Civil and Commercial Code, at sections 1417 to 1434, provides for the right of usufruct. In Thai, Siti Kep Kin. A usufruct entitles the holder to possess, use, manage and take the fruits of immovable property belonging to somebody else. It is not ownership. The usufructuary cannot sell or mortgage the underlying land, but it is a real right, a right in rem, and once registered on the title it attaches to the land rather than to a promise. It may be granted for a fixed term of up to 30 years or, and this is the crucial option, for the lifetime of the usufructuary. There is no nationality restriction in the statute. Foreigners register usufructs over Thai land routinely, though it should be said plainly that registration is subject to the discretion of the local land officer, who may scrutinize whether the arrangement is being used to circumvent the foreign ownership prohibition, and practice varies noticeably between provinces. What a registered usufruct does is best captured by two principles that Thai property law shares with the civil law tradition it draws from. The first is droit de suite. The right follows the property. If the owner sells the land, the buyer takes it subject to the usufruct. If the owner dies, the heirs take it subject to the usufruct. If the owner goes bankrupt, the right survives. The registered usufructuary's entitlement to live there and use the property is unaffected by a change in who owns the title, and the Supreme Court has confirmed the breadth of the usufructuary's management powers over the property, including in decision number 15033/2555. The second principle is droit de priorité. Where multiple real rights are recorded against the same title, priority runs by date of registration. Older registered rights rank ahead of newer ones. Sit with that second principle, because it is the practical heart of this entire subject. If a usufruct is registered on the title before a mortgage, the usufruct ranks first, and it constrains what comes after. A lender examining that title sees an encumbrance that will survive enforcement, values the collateral accordingly, and will very often decline to lend at all, or will demand that the usufructuary formally subordinate the right, which requires the usufructuary to appear at the land office and sign, which means he finds out. The usufruct in that sequence does two jobs at once. It protects occupation, and it functions as an early warning system because it makes the property difficult to encumber quietly. If the usufruct is registered after the mortgage, it ranks behind, and it will not survive an enforcement sale in the way the holder assumed. Same instrument, same cost, radically different outcome, and the only variable is the order of the entries on the back of the deed. Register early. Register before the money moves, not after the relationship has gone quiet. The usufruct has a real limitation, and it should not be glossed over. It is personal to the holder, and it terminates on his death. It cannot be inherited. Thai courts have accepted that a lease granted by a usufructuary during the usufruct can in certain circumstances survive the usufruct's termination, which opens a succession planning route for those who need one, but it is a technical structure that depends on the lease's term and registration, and it needs a competent lawyer rather than a forum post. Alongside usufruct sits superficies. A right of superficies separates ownership of the land from ownership of what stands on it, and it permits the holder to own buildings and structures on land belonging to another. For a foreigner, this is significant, because while he may not own the land, he may lawfully own the house. It can be registered for up to 30 years, or for the life of the holder, and unlike usufruct, it is transferable and inheritable, which makes it the instrument of choice where the concern is passing something to children. It is registered at the land office and recorded on the title, subject again to the local office's practice. The code also provides for habitation, a right to dwell in a building, which is narrower than usufruct, non-transferable, and generally the weaker choice where usufruct is available on the same facts. Since superficies turns on owning the building rather than the land, it is worth knowing how building ownership is actually evidenced in Thailand, because there is no chanote fee for a house. What exists is a construction permit issued by the local authority, naming the person who commissioned the build, and a house registration book, the Tabian Ban, which records the address and its registered occupants. Neither is a title deed, and neither proves ownership on its own, but together with the building contract, the receipts, and the record of who paid the contractor, they form the evidential trail that supports a claim to the structure. A foreigner cannot be entered in the standard blue Tabian Ban, but may be registered in the yellow book, the Toror 14/1, which is the foreign residence equivalent, and which is genuinely useful for opening bank accounts, dealing with utilities, and demonstrating residence. Get the construction permit in your own name where you are the one building. Keep the contract, the payment records, and the bank transfer evidence. Register a superficies over the completed structure. Done together, those steps mean that if the land is ever sold or enforced against, there is a registered right and a documented ownership claim over the house standing on it, rather than a very expensive gift to whoever holds the deed. Then the lease, which is what most people are actually sold. Section 540 of the Civil and Commercial Code caps a lease of immovable property at 30 years. Section 538 provides that a lease of immovable property is unenforceable by action unless evidenced in writing signed by the party liable, and that a lease for more than 3 years, or for the life of either party, is enforceable only for 3 years unless made in writing and registered with the competent official. A registered lease binds successors in title under Section 569, so it survives a sale of the land. An unregistered lease over 3 years collapses to 3 years, which is the mechanism by which a number of people who believed they had 30 years of security discovered they had 3. A commercial purpose lease may run to 50 years under the Hire of Immovable Property for Commerce and Industry Act of 1999, but only for genuine commercial activity, not residential use dressed up. For roughly 2 decades, the standard structure sold to foreign buyers of villas in Phuket, Samui, and elsewhere was the 30 plus 30 plus 30, an initial registered 30-year lease with pre-agreed renewal clauses, sometimes with the renewal periods paid for up front, sometimes with pre-signed lease documents held in escrow, marketed as 90 years of security and as functionally equivalent to freehold. It appeared in glossy brochures. It was drafted by real firms. Buyers were repeatedly assured it was standard and safe. The Supreme Court, in decision number 4655/2566, held that it does not work. The court found that renewal clauses agreed at the outset of a lease, which are designed to extend the term beyond the statutory 30-year maximum, are void and unenforceable. It grounded the decision in Section 540 and in public policy, reasoning that the 30-year limit protects both parties in relation to the economic value of the property, and that arrangements running 60 or 90 years bind future parties across decades of unpredictable change in value, condition, and circumstance. Critically, the court looked at substance over form. Schemes using multiple pre-signed leases or stacked pre-agreed extensions to reach the same destination were treated the same way, and the invalidity was not cured by any of the things buyers had relied on. Not by the parties' mutual agreement at the outset, not by rent having been paid in advance for the renewal periods, not by registration of the original agreement at the land department, void from the beginning. The ruling was widely circulated through 2025 and is being applied by lower courts. 2 things about it should be understood precisely, because there has been a good deal of loose commentary. First, if your initial 30-year lease was properly registered, it is unaffected. The court struck down the pre-agreed renewals. It did not disturb the underlying registered term, and there is no need for anyone holding a valid registered lease to panic. Second, a lease can still be renewed. What cannot be done is binding the lessor in advance to renew. A renewal agreed and registered at the time renewal falls due is perfectly good. The distinction is between a real right registered on the title, which binds the land and everyone who later comes to own it, and a personal promise between 2 individuals, which binds only them and which is worth nothing if the land has changed hands, the owner has died, the company has been wound up, or the promisor has simply decided otherwise 30 years later. Where renewal fees were prepaid under a void clause, the principle of unjust enrichment applies, which gives a route to recovery and also a long argument with somebody who may no longer exist as a legal entity. Since 2019, there has also been Sap Ing Sith, the right over leasehold asset, created by the Sap Ing Sith Act BE 2562. It is a registrable real right over Chanote titled land, buildings or condominium units, registered directly on the title and binding on future owners, heirs and creditors of the landowner. Its advantages over an ordinary lease are genuine. It is freely transferable without the landowner's consent. It can itself be mortgaged. The holder may alter or add to the property without permission, and it is inheritable. Its limitations are equally genuine and are frequently soft-pedaled in marketing. The maximum term is 30 years. The Act contains no renewal mechanism at all, so claims of 60 or 90-year Sap Ing Sith terms have no statutory basis whatever, and structures on the land revert to the landowner when the right terminates. It is a stronger instrument than a lease for the period it runs. It is not ownership, and 30 years is 30 years. Reform proposals to extend maximum leasehold terms to 99 years have circulated repeatedly, championed at senior levels of government, and driven substantially by real estate industry lobbying. As of mid-2026, none has been enacted. Structure your affairs according to the law as it stands, not according to a bill that may pass, because if it does pass you can always restructure into it, and if it does not you will have built on nothing. Which leaves the nominee company, and this is where the ground has moved most sharply. The historical workaround for foreigners wanting land was to incorporate a Thai limited company with Thai shareholders holding the majority, and have the company hold the land while the foreigner controlled the company through some combination of preferential voting rights, powers of attorney, undated share transfer forms, and loan agreements. Section 96 of the Land Code criminalizes both the use of nominees and the act of serving as one. This has been the law throughout. What changed is enforcement. Through 2025 and 2026, the Department of Lands has run a systematic enforcement campaign. A 2026 circular activated a pre-existing operational manual, the Manual of Guidelines for Implementing Measures to Prevent Landholding on Behalf of Foreigners, issued under a 2023 circular and consolidating enforcement directives going back over a decade, which sets out a standardized process running from detection and screening through fact-finding, interagency coordination, criminal referral, and forced sale. The stated intention was to eliminate the provincial inconsistency that previously made enforcement a lottery. The Department of Business Development has been investigating nominee shareholding in high-risk sectors including land trading, real estate, tourism, hotels, and construction. AI-assisted screening tools have flagged large numbers of companies, and hundreds of prosecutions have followed. Enforcement has appeared in secondary markets and provincial locations, not only in the resort areas, which tells you the campaign is national rather than symbolic. The decisive point is that 51% Thai shareholding on the register answers nothing. Authorities are examining substance, whether the Thai shareholders made a real financial contribution or were paid to lend their names, where the subscription money actually came from, whether the foreigner transferred funds to the Thai shareholders shortly before incorporation, whether control runs through side agreements, powers of attorney, or blank share transfers, and whether the company conducts genuine business or exists solely to hold a house. A Thai company holding land is not automatically illegal, and many are entirely legitimate. It now has to be able to prove it. Where an illegal nominee holding is confirmed, the Land Office can freeze the title, and under Section 94, the owner is ordered to dispose of the land, typically within a window running from 180 days to a year, with the proceeds going to the owner. There are proposals under formal study that would replace disposal with outright forfeiture to the state without compensation, would raise financial penalties, and would classify nominee violations as predicate offenses under the Anti-Money Laundering Act, opening the way to asset freezing and criminal prosecution. Those proposals are not law as of mid-2026, but nobody holding land through a nominee structure should take comfort from that, because the existing statutory tools are already sufficient to force a sale, and they are being used. Set against all of that, here is what actually works, in order of strength. Own a condominium unit in your own name within the 49% foreign quota, with the purchase funds remitted from abroad and documented on a foreign exchange transaction form. This is unambiguous, it is safe from the nominee enforcement entirely, and it is the only route by which a foreigner holds Thai real estate in freehold. If your requirement is a home rather than a house, stop reading and do this. If it must be land, do not rely on a single instrument. The structure competent practitioners assemble is layered, a registered 30-year lease over the land, giving a real right that binds successors, a registered superficies over the building, so that you own the structure, and so that ownership is transferable and inheritable and survives the lease, and a registered usufruct, where the relationship and the land office permit it, giving lifetime occupation and income rights. Each is a separate land office filing with its own fee and stamp duty, and for a substantial villa, The total registration cost across all of them typically runs a few 100,000 baht. That is meaningful money. It is also, in every case I have described in this video, a small fraction of the sum at risk, and it is the difference between having rights recorded on the back of a deed and having a recollection of a conversation. There is a further mechanism that is entirely lawful, widely available and used by almost nobody, and it deserves more attention than it gets. A foreigner cannot own land in Thailand, but a foreigner can be a mortgagee. He can lend money to a Thai national and take a registered mortgage over Thailand as security for that loan, exactly as a bank would. The structure is straightforward. Rather than handing over the purchase price as a gift, you advance it under a written loan agreement, in Thai and English, specifying the sum, the term, and the repayment obligation, and you register a mortgage over the land in your own favor, at the land office, at the moment the land is acquired. The registration fee is 1% of the secured amount, plus 0.05% stamp duty, and the mortgage is then annotated on the reverse of the deed for everyone to see. What that gives you is threefold. Your interest is registered, dated, and senior, so any later lender ranks behind you, and will price or refuse accordingly. A mortgaged property cannot be transferred without the mortgagee's consent, which means the land cannot be quietly sold out from under you. And if the arrangement collapses, you hold a secured claim for the money rather than an unsecured grievance about it. You can enforce through the courts as a creditor, which is a real remedy, as opposed to attempting to revoke a gift under Section 531 and discovering that ordinary betrayal is not on the list. It is worth being honest about how this feels. Asking someone to sign a loan agreement and register a mortgage in your favor at the same appointment where you are buying them or their family a house is not a romantic act, and a great many people cannot bring themselves to raise it. That reluctance is understandable, and it is also the exact mechanism by which the money is lost. The conversation is uncomfortable for about 20 minutes on one day. The alternative is uncomfortable for the rest of your life. And a person who genuinely intends the arrangement you both described has no reason to object to it being written down, which is information worth having before rather than after. If the land is going into a partner's or a family member's name, register a usufruct in your favor at the same appointment, on the same day, before the transfer is complete rather than after. The sequence is not a formality. It is the entire protection, because priority runs by registration date. Doing it on the day it is done, as one transaction, avoids the conversation that becomes impossible to have 3 years later, when raising it means announcing that you have started to wonder. If you are gifting, and you intend the gift to carry obligations, that the property will be the family home, that it will not be encumbered, that it will not be sold, write a gift agreement recording the charge before registration. Section 528 gives a route to recover a gift where an agreed charge is not performed. Nothing recovers a gift where the expectation lived only in the conversation, and understand before you sign that a gift made in consideration of marriage is not revocable for ingratitude at all under Section 535. Before any money moves, instruct a Thai lawyer who is not connected to the seller, the agent, or the developer to conduct a physical title search at the provincial land office, inspect the office's original Chanote, read the encumbrance register on the reverse, and confirm the title type, ownership history, existing mortgages, leases, usufructs, servitudes, and seizures. Commission an independent boundary survey if there is any doubt about the plot. Treat anything less than a Chanote or a Norsor 3 Gore as high risk, and take specific advice before proceeding. Accept no photocopy from anyone as evidence of anything, and remember that the Department of Lands itself says its online map service is not legal evidence. And if you already hold something structured the old way, a nominee company, a 30 plus 30 plus 30 lease, a house on land in someone else's name with nothing registered in yours, get it reviewed now rather than after an event. Restructuring is possible. A nominee company can sometimes be unwound into a compliant structure. A prepaid renewal may support an unjust enrichment claim. A usufruct or superficies can be registered today over land you have no interest in. If the owner is willing, and willingness has a way of declining over time. What cannot be fixed is a right registered after the mortgage that outranks it, or a revocation claim brought 7 months after the donor learned the facts. The thread running through all of it is the same, and it is simple enough to hold in your head without a lawyer present. Thai property law is a registration system. It does not much care who paid, who intended what, who was promised what over dinner, or whose retirement funded the concrete. It cares what is written on the back of the deed, and in what order. That can feel cold, and it is worth noticing that it is not cold at all. It is the same principle that makes the register reliable for everybody, including the family whose only asset is that document. A system that could be overridden by unwritten understandings would protect nobody. The rules are not different in Thailand. They are written down, they are published, they are available in English, they are enforced consistently, and they can be complied with by anybody willing to spend an afternoon and a few 100,000 baht before rather than everything afterwards. What is different in Thailand is only the number of people who arrive assuming the rules will bend for them, and the register has never once been persuaded.